Okay, good morning, ladies and gentlemen, and thank you very much for joining us on officially this, not beautiful, but it is a spring morning in the United Kingdom. So spring is here, everything's feeling super positive. My name's Kerry Hallard and I'm the Chief Exec of the GSA, and I'm absolutely delighted to welcome you to this webinar. It's been a bit of a GSA pop-up. We've put it together really quite quickly based on the feedback and demand we've been getting from our membership community. And it's all focused on contracting for the new technologies. So by way of backdrop, we all know how much the world has actually changed on a pin, whether it was through the pandemic, whether it's obviously through all the geopolitical uncertainties, whether it's the cost of living crisis. All of these things are happening and having a huge impact on the way we negotiate and deliver a lot of the contracts across the technology and business services arena. So you've got all of these forces of change happening simultaneously as demand is actually going through the roof, and everybody is looking at implementing new technologies, digital transformations, moving into the cloud, and actually looking at how new startup techs can really help them transform their businesses. So we've got a little bit of a perfect storm. So what we've curated today is a panel that will be able to talk us through the new techs, what's coming to the market, how you contract for them, what of the art of the possible is for actually negotiating with the hyperscalers, and then looking at some of the best practice for contracting across tech, and then also some new innovative approaches to bringing tech into your sourcing arrangements. So we've got a fantastic panel, and without further ado, I'm delighted to introduce our first speaker. So Praveen Gupta is a senior director and also practicing consultant with Neo Group. Neo Group is one of the newer advisory kids on the block, but they actually won the GSA Advisory Firm of the Year last year. So congratulations on that, Praveen, for Neo, and welcome, and the floor is yours. And just before we go any further, what I should say is there's going to be loads of, please put chat in, please put questions in chat, and there'll be loads of time for Q&A, which will be taken at the end. Cool. All right, sorry, Praveen, over to you.
No, thank you. Thank you, Kerry, for that introduction, and thank you for having me here. Thanks everyone for joining. So the next 10 minutes, I'll spend talking about our experiences at Neo, contracting and buying new technology. Let me share my screen right away here. Is the screen visible?
Yep. Yep.
Yes. Okay, very good. Okay, so when we say new technology, in simple terms, if I have to define what is new technology, it pertains to everything that really in the field of IT that does not pertain to an FT or an underlying infrastructure asset. So all the new technologies that you see over here, I'll not go through each of them, but these are our view of new technologies. A lot of work we have been doing is around cloud and industrial automation. So most of my discussion will be centered around this, but what we talk about would generally be applicable across most of these new tech areas. So with that introduction to new technologies, I'll move into some of the key recommendations that we have when buying and contracting for new technologies. I'll spend the next 8 minutes, 2 minutes with each of the recommendations. These are, of course, not the only ones, but in the interest of time, we had to find the really key ones. So number one is we need to contract for ambiguity and uncertainty. When dealing with new technologies, it's not like conventional sourcing, right? Where we really are defining very tight boundaries for the supplier, and we say, okay, these are the requirements. You have to adhere to these requirements and come back with the solution. Come back with the end state. We know the end state in these cases in conventional sourcing, but really in new techs, we are not aware of the end state. We do not know what this transformation might lead us into, right? So what we do in sourcing for new techs is we do it incrementally. We go one step at a time. We set up the enablers so that we can make assessments. We can identify areas that need to be transformed, and then as those areas are identified, we do further rounds of sourcing uh, to transform those identified areas, and that's what we call agile sourcing. It's more iterative, and you are kind of exploring something in contrast to conventional sourcing, where you have a destination in mind and you are just targeting that destination. You are straight away going to that. So that's the difference between conventional and the new techs. And how does it translate in the actual contract? So in actual contracts, you will see a lot of contracts are based on consumption ranges, volume ranges. They won't be absolute numbers like we have in like conventional sourcing. You would have a rate plan rather than a committed volume. You'd have different tiers for rates, right? Charge rates, for example, for different tiers of consumption. So all that ambiguity has to be it, basically on all that ambiguity is what you are trying to address by having this kind of a contract. So that's the first thing I wanted to leave this group and rest of you with, so that we can discuss more on this. Let me turn off this. Some notifications I'm getting, so I need to turn off this. This IM. Okay. So the second thing is, so when dealing with new technology, and this is specifically pertaining to cloud and allied technologies, we have two ways of sourcing. One is sourcing directly from the hyperscalers. The hyperscalers, as you know, the AWS and the GCPs of the world, AWS, Azure, GCP, Oracle Cloud, hardly 4 or 5 of them that are there in the industry. And if you contract with them, there is perception of greater control. There is perception of, and it's true as well. I mean, I'm not saying that it's not true. It's you have greater control, but what you don't have is that you are kind of contracting only for a very specific area, which is infrastructure as a service. You would have to really build a lot of things. You would have to really build a number of allied products and services around this to have a successful transformation. And all those allied services, when dealing with hyperscalers, we can get it from their marketplaces and their alliance partners. So that is one mode of sourcing. But the other mode is sourcing with the managed service providers. If you source the same set of services from managed services providers, who in turn also operate as cloud resellers. So they will be providing you cloud services. They'll also be in turn negotiating on your behalf with the other providers, which is providers of industrial devices, providers of IoT sensors, etc. So so all those basically the task of integrating multiple engagements, and the uh, task of ensuring that you are operating at an optimum level with each of these small sourcing engagements, sourcing for AI/ML, sourcing for tax, etc., is taken care of by the MSP. And typically MSPs um, are more capable of getting the best deals compared to buyers, because as buyers, we have very limited, as buyers and representative of buyers, for example, as advisors, we have very limited access to benchmarks on these new areas like IoT and AI/ML, and that's where the challenges start. So So I'm not leaving you with any recommendation on this, but this is again a discussion item. There's no right or wrong answer on which approach to take. And I guess Kit is on the panel, and he'll be speaking more about these things when it goes to him, because yeah, so he's. I'll move on to the next one just in the interest of time. The third one is when dealing with new techs. Please interrupt me if you need to. Otherwise, leave questions on the chat, and I'll try to address them at the end. The third one is keep a tab on the commitments you make. What I'm suggesting here and what we have observed doing new tech deals is the industry is really changing very fast. Deals that we did 3 years ago, we realized that we could have done something differently. There's a new provider who's providing something far better, and now we don't have an exit path, right? There are this particular industry, and like many others, these industries operate in economies of scale, which means the bigger the pie, the lesser is their cost, and which means there is a lot of mergers and acquisitions, and eventually the industry ends up being an oligopoly. We have seen this with operating systems, like you have only Windows, iOS, and Android, for example. We have seen this with public cloud industry, AWS, Azure, GCP. I mean, maybe Oracle Cloud. Not many providers, but look at how many providers we have on industrial IoT, for example. Look at how many providers we have on AI and ML. There are small and medium enterprises, and a number of them, which we don't know whether they'll exist 5 years from now. And that's why we strongly recommend not to contract for term longer than 3 years without an exit option. We strongly recommend not to trade in flexibility to pay per use in return for discounts. I mean, it's tempting to get discounts, volume discounts, and discounts for commitment for 5 years, 7 years, 10 years. But we strongly recommend not to go into this. And we also, in our experience, when we do these deals, we only commit about half of the volumes of what we actually expect to consume. I'd leave this slide with this statement. I mean, cloud, industrial IoT, they were designed for pay-as-you-go, right? They were never designed for a take or pay pricing. And that's what this slide talks about. The fourth thing is, so this is not very strategic, it's a bit tactical, but I still wanted to leave you with this because we are increasingly seeing CPI has become a hot topic, especially in the last 2 years with what has happened, how CPI is the consumer price index or the retail price index in some geographies. This has shot through the roof in the last year or two post-COVID. So what we are seeing is that suppliers are insisting on a CPI linked increase in prices. But as buyers and representative of buyers, we are pushing back on suppliers especially on suppliers which are not tied, whose services are not tied to an FTE, new technologies, right? They are not tied to an FTE. They are not tied to an underlying asset. In all probability, what you are, for example, if you are renewing a contract, in all probability, the initial cost of the license has already been paid off, has already been recovered. Typical break even for SaaS products is 3 years. So any kind of renewals, we have to insist on continuous productivity and price improvements, and kind of not go for a CPI based increase. That is our fourth recommendations. We have successfully done this with some of the vendors. We have been unsuccessful with some, but this is something that we need to keep in mind. So yeah, that's it from me. I'd like to open the discussion to the panel and hear more from everyone in the panel as well as in the audience.
That's great. Thank you, Praveen. You made some pretty provocative statements there, and I'm going to be really interested in speaking to the rest of the panel to see whether they agree with some of those statements or whether they could counter those. But we've got to wait for the panel for that. So thank you for that, Praveen. And now I'd like to move on to our second speaker. So Charles Mallows, you're working in the technology and sourcing division within Charles Russell Speechless. So over to you, Charles. I think you're going to give us a little bit of an overview on the best practices when contracting for techs.
Yes, look, a bit of a whistle-stop tour. Let me just share the slides that I have, if they want to pop up.
I'll let you know when they're there.
No, they're not, because I can't find them. Fantastic. So they're open on my desktop, and they are not opening in Teams. Let me try one more time.
Or does Abby have them?
No, she doesn't, unhelpfully. Sorry, that's my fault. Okay, I'm going to share my screen rather than share the tab. So if you get any WebEx notifications or anything pop up, please ignore them. Here we go.
Okay, I'll let you know when they're there.
They should be now.
Yeah, we've got you.
So this is just intended as a bit of a whistle-stop tour on what we're calling best practice for buying and contracting for new technologies. I would say that this presentation is mainly aimed at those procurement specialists in the room, but it's probably also a helpful reminder to us as lawyers how we can help and assist our clients or our internal clients when we're contracting for new technologies. So in terms of best practice, I think fundamentally the most important thing is to set the groundwork of your procurement early, to understand exactly what outcomes you're trying to achieve by procuring this new technology. What can you do to get there? What are the stages that you need to get through to get to your end goals? Make sure you've got buy-in from your key stakeholders within the business at every level of the organization to ensure that you've got, as I say, a strong working relationship with both internal members of the business, but also a good understanding of what your external suppliers can deliver. You need to make sure you've got the right resources in place within the business to conduct a successful procurement, and that includes having whatever function within the business that's intended to drive the process. So it would normally be, in my experience, an IT team able to explain rationale, drive the commercial argument, and be able to explain to everyone what the purpose is behind purchasing the new technology. I would always say get your legal team involved early and as early as possible, because we as lawyers can add a lot of value add early on in processes where strategies are being set and where the structure of deals is being put together. And it's at that stage that we can assist with explaining what potential risks there may be, but also helping with any internal compliance obligations, and, as I say, structuring a deal so there's less pain later down the line. Quite frequently with these sort of deals where we are engaged early, it's a case of dipping in early and coming back a bit later once the commercial work has been done and there's a better understanding of what the project's going to look like. But at least we've got the buy-in and the understanding to begin with. One thing I think that's important as well is particularly where you're dealing with a sort of disaggregated model where you've got multiple suppliers, is making sure that your contracts knit together well. By way of example, I was working on a deal a couple of years ago for a client in the financial services sector who was procuring a sort of automated aggregating tool in relation to market data, where they were sort of drawing market data through to help their front desk execute trades. And we were brought in quite late in the process to deal with the negotiations with the market data provider, and the customer themselves, our client, had sort of gone off and already agreed terms with its software vendors who were developing the automated software, and then had already started their process of development and design. And at this stage, where we were brought in, we come in and have a look at the terms, and big boy market data provider non-negotiable terms or very little wiggle room for our client, but within those terms are a lot of flow downs and rules that are geared around how third parties were permitted to use APIs and license use of that data, which obviously hadn't been flowed down because there was a imbalance in the process where, you know, client hadn't focused on the big contract first, but focused on the stuff that needed to get done early without full understanding of the deal structure. And what that really meant in practice was undoing a lot of what had been agreed with those software vendors originally, so as to be able to flow down the obligations from the data provider. In the end, look, not a massive deal, but it was additional time and expense that could have been saved with setting groundwork early and understanding exactly what the whole process was going to look like. We as lawyers can also assist at an outset with understanding at a high level what risks there are likely to be in procuring new technology. And there I'm thinking of things like ownership and management of data, both personal data and any other sort of company-owned data that may be important, dealing with any issues in terms of resilience and how that's managed. And again, I'm particularly thinking about scenarios where you have got disaggregation and multiple suppliers and there's multiple vectors for potential risk for the business, dealing with any sort of regulatory and compliance issues, or at least having an understanding of what they might be. Again, particularly relevant in the financial services sector where you have multiple bodies with rules and processes that need to be followed depending upon your assessment of what it is that you're buying and its importance to the business. Dealing with any IP ownership, considering what may happen if there's a supplier failure and what other options there are in the market and what risks there are if things go south. I think quite often with new technologies, you're swimming in a small pool, and quite often there may only be one supplier that's able to deliver what they say they're going to deliver. So do you have a plan for moving on if that's the case? And all of that sort of knits in within some of these other points like ownership of IP, escrow, that sort of thing. Are there any licensing or use restrictions that your suppliers impose upon you? Is that going to have a knock-on effect upon how you use whatever it is that you're procuring within the rest of your business? So there's lots of things to consider. All of those things can be brought together for consideration early on. Now they may change as time goes on, but it's worth having some form of, someone in control of the process who can understand those points and who can manage and maintain that assessment as the procurement goes on. Now, in terms of contract considerations and drafting, I think what we're seeing, particularly with sort of commodity-based supply, is that you've got a lack of negotiation with a lot of suppliers, and that's based upon long supply chains and multiple pieces of products and kit fitting within offerings. So the sort of traditional focuses of contract negotiation are not always necessarily there, and actually a lot of what can be added in terms of value is focusing on the stuff that's shown on this slide, which is sometimes overlooked when you're talking about when you're going through a contract negotiation. But these are sort of key areas.
Charles,
yes,
you haven't moved the slide on yet.
Oh, it's showing on my screen. Let me try again.
Thanks.
Is that better?
No, we're stuck on the opening slide.
That's very bizarre. Okay, let me minimize, and then sorry about that.
No,
I think you are presenting the wrong screen, the display screen that I'm seeing.
oh, we've gone to the last slide. We're on the third
Yeah.
slide now. We're on
Is it
3 out
showing
of 4.
now?
Contract
Okay.
considerations.
So I'm looking at my present screen, and you're just looking at the PowerPoint doc. Sorry
Issue of
about that.
technology, isn't it?
Yeah, well, there you go. What an embarrassment for a tech lawyer. Sorry about that. There you go. Look, so we've got here, these are what I would see as important contract considerations, aside from, look, still focus on liability and service description and security and data protection and all of those things. But here are some other areas where we can really focus that can help drive an agile project. So we've got dependencies and clearly setting out, who's responsible for what at the outset. If you've got an internal IT team that's delivering something that fits within your overall project, make clear what that is, and make clear where the dependencies fall upon the parties. If you've got a variety of suppliers, you can have schedules which clearly set out responsibility across the piece. I mean, I found typically that where you do have that disaggregated model, suppliers aren't exactly willing or desirous of entering into a multi-party agreement. So part of the work is trying to get those dependencies to flow accurately between your various contracts. And as part of that comes clear governance procedures, and also an easy to follow and easy to operate change management process. So I think governance is important. It's important to go beyond your sort of boilerplate governance provisions and understand exactly what it is that's likely to be an issue later down the line in your contract, and cover the management of that with accurate drafting, so that the parties have a good understanding of how they can manage their relationship going forward. And from a change perspective, again, we're dealing with new technologies here. We're dealing with tech that may well become regulated in the future. So it's sensible to have a process whereby you can easily agree changes to the contract, and also agree to any additional or variation in pricing that goes along with those changes, and have a process that's set out within your contractual structure. The parties know at the outset what they're going to have, how they're going to have to operate that when those triggers arise. And I've also added on here KPIs, and say KPIs sort of separately to your traditional SLAs and service levels, as a sort of softer approach perhaps to service levels and service credits, but having a set of performance indicators that are effectively checkpoints for each party, so they can make sure that the process is progressing as each party wants, and you can track, as a customer, you can track value through your hitting of KPIs and proper reporting and management. I think that's probably my 10 minutes. So I won't go through the other key terms that we've got listed here, but they're all your standard, your sort of standard considerations. And Praveen talked about fees. Just quickly on that point, I mean, I think what we're seeing mostly now on fees is a sort of blend between your T&M and fixed approach. So you've got a mixture of fixed costs and then a rate card for additional PS, or sometimes bank towers or things like that, where you've got upfront pricing, but the ability to call off time under those prices. And yes, I mean, price increases, just thinking about CPI increases or RPI increases, or whatever's being requested. One thing that we've been able to do in negotiations on those points recently is to agree to RPI as an increase mechanism for fees, but also have a cap on that, so that you've got a sort of maximum level that you can reach, given the recently very high rates that we've been seeing. So that's the end of the presentation. There are my details. No picture, but you can see me on screen, and you can find my details on our website.
There's been a request, Charles, just to quickly flash up slide number 2, so we can see the topics that were included there. So there we go. Fantastic. Right. So just let everybody have a quick look at that and probably take a photo or something. But the slides and the presentations are going to be distributed post event. So
yes, happy to share them. Yeah,
excellent. That's great. So you've pulled up a number of points that we really want to dig into later, a lot of it being around RPI and when to bring lawyers into the contracting process. But we'll, again, save all of those conversations for the panel. So thanks very much, Charles. Right,
Lisa.
absolutely delighted to introduce our next speaker. So long-term friend of the GSA and probably multiple award winner as well. So Kit Burden probably needs no introduction, but out of politeness, I will do so. So Kit leads the technology and sourcing practice for DLA Piper. So Kit, you're going to talk us through the art of the possible with hyperscalers. You're on mute, Kit.
Yep,
Yeah,
Emily,
you got
thanks
it.
for the introduction, Kerry. So let me start by sharing my slides. So let me know when you can see the slide deck.
Good to go.
Super. Okay, so I'm going to run through these relatively quickly, but I'm also going to share the slides afterwards, so you don't need to worry if I don't cover all of the points that we go through. But I wanted to set the scene first up in terms of talking about hyperscale cloud and why it's important. But the reality is that we have a huge variety of different types of cloud offering, as you can see from the bullets that are put on this slide. And these range from small niche offerings all the way through to effectively enterprise in the cloud. So the kind of situations where business critical applications and business critical data is now entrusted to the cloud provider, which puts a very different perspective on things. Now, what that has meant is that a lot of deals that historically might have been as a managed service or an outsourced deal are instead now characterized instead as an as-a-service deal, and particularly with platform as a service and infrastructure as a service are very good examples of that, but we also see ERP in the cloud and so on. And I think a number of the early speakers have alluded to, there is then a change in the bargaining position between the parties, because organizations like banks or like big utilities or FTSE 100 companies who've been used to having their way to a large extent in contract negotiations for technology services are suddenly coming up against big hyperscale cloud service providers who also have a lot of leverage and who also feel themselves to be somewhat more constrained in terms of what flexibility they have in terms of their contract terms. So the result is that there is actually a lot less negotiation possibility for the customers than perhaps they would have been historically used to. Now, in the time we've got available, I'm not going to cover all of the key battlegrounds, but I want to cover 4 in particular, and those relates to the rights to vary the service levels, suspension rights, so something short of actual termination, the termination rights themselves, and particularly the consequence of termination, and then inevitably something about remedies. So in terms of changes, obviously it's something of anathema to lawyers and contract negotiators, the idea that you sign a contract and yet it could change underneath your feet. But cloud service providers have got a very good reason as to why they believe they need a right to change, and it's based upon the one-to-many principle. The idea, therefore, that you can't be constrained in making a change to your solution or the terms for it that are necessary to maintain competitiveness just because one supplier or one customer doesn't like it. And that's encapsulated by this quote, which is pretty much verbatim what we've heard from different cloud service provider representatives in the past. But this really says you just got to trust us that we won't change things in an unreasonable way. But I trust only in God, death, and taxes, and therefore I do try to think about ways which we can protect our clients in these circumstances. And the reality is that there are certain constraints that can be placed upon changes to the terms. So, for example, if you're going to change the nature of the services, can this only be positive in the sense of adding services as opposed to taking key functionality away? Does the customer have the ability to walk away from the deal without penalty if the changes are such that it doesn't like it? It may actually remove some key functionality for them, which may not be so key for other customers. And if the service levels are going to change, are they also only on the basis of positive changes or something which is to the benefit of the customer? And if there are references to changes in the contract terms themselves, on what basis do those need to change? They shouldn't be just to reflect the commercial risk of the supplier as opposed to something which is solution specific. And it's certainly, if the changes were being made to the data protection related provisions, there would be a very good case to say that that would not be permissible in any event by virtue of the underlying data protection legislation. When we talk about suspension rights, suppliers will typically argue that because, again, of the one-to-many delivery model, they need to have the ability to stop the bleeding, as it were, for a problem that has emanated from a single customer before it can infect their ability to provide services to the rest of its customer base. And that we can understand, and after all, continuity of service is key, and you would, as a customer, want the cloud service provider to cut off an infection of that type if it was coming from another source. However, because these cloud services are increasingly absolutely key to the customer, it could be akin to turning off your business. And if the supplier has the right to do that in too much of a hair trigger scenario, and could do that without any liability for itself, there is a very significant business continuity risk. So what you need to look at is some degree of constraint on the ability of the supplier to undertake a suspension, to make sure that it really does only occur in the more extreme circumstances. And you can see I've put up on the slide here a series of suggestions as to the kind of constraints that we've seen put in place in times past. One of the other things that you can look to do is at least make sure that you're going to get some kind of prior notice in the event that a suspension is going to take place, and an opportunity to put it right if you're able to do so. So it could be, for example, that there is a breach of an acceptable use policy which could be readily rectified, and you would not then want the services to be suspended if you're able to do that without any kind of real delay. You'd also want the supplier to be under some kind of positive duty to at least minimize the scope of the suspension, both in terms of extent and duration. And I would suggest that it would be worth you considering what kind of remedy you would want to have against the supplier in the event that the cause for its suspension is found not to relate to the customer. In other words, if it's alleged that the customer has been at fault in terms of its use of the system, but it turns out not to have been the case. Because if the supplier knows that it will have some kind of compensation obligation to the customer in those circumstances, that's going to make it a lot less willing to just arbitrarily suspend without doing some kind of meaningful investigation first. Well, that brings us on to termination rights, which is very much the H-bomb scenario for services, again, particularly as we move into enterprise clouds and more business critical services. Now, as many of you will know, in the outsourcing market, which many of these cloud services now are akin to, we've moved to a situation where very often the supplier doesn't have a right to terminate in anything other than the circumstances where there is a non-payment of undisputed fees. That's not the typical position in hyperscale contracts, however. If anything, the termination rights seem to be more favorable to the supplier than they are to the customer. And certainly you would have typically a material breach related termination right, and in some cases even rights for the supplier to terminate for convenience. And if you were to pick up any of the standard terms for the cloud providers, you would often see that the only obligation post termination that is placed upon the supplier is just to return the data of the customer within a short period, 30 to 90 days being pretty typical. Now, that's really, really problematic, because if you think that many of these cloud arrangements are replacing outsourced or managed service type deals, typically you would then need there a very lengthy termination assistance period so as to enable there to be a retransition of responsibility for the provision of the services either back in-house or to a replacement provider. And I don't think that requirement changes just because the service delivery is now cloud enabled. As any of you who've done one of these procurements will know, it isn't as simple as just switching across from one utility provider to another. There will typically be a period of multiple months whilst data is migrated, applications are remediated, a procurement process is gone through, and you go through a full migration process. So from a business continuity perspective, it's an absolute must-have that you have protection of continuity of service during that period. So what we see being focused upon in the negotiations here is certainly to delete any concept of a right of termination for convenience for the supplier, some injection of reasonableness and materiality in terms of any breach-related termination rights, albeit we haven't yet seen the market move to where the outsourcing market got to on that. But most importantly is a commitment that there will be a continuation of services for at least a transitionary period post-termination, and usually for a period of multiple months. And we frequently see periods of between 12 to 18 months in that regard, much as we would have done in a more traditional outsourced deal. So I think that's definitely where the market is now, and certainly when you're negotiating more business critical deals, we'd strongly recommend that you look to that type of structure. So then finally, in the time available, I'm going to talk a little bit about remedies and sanctions, because the reality here is that the typical drafting one of these contracts is for very limited rights of recourse against the supplier. Again, you'll see up on the slide that put up on the screen now, just a few examples of typical provisions which are very restrictive in terms of the liability that the supplier will take on. Now, that's a difficult sell up to the C-suite level, because if something does go wrong and it really does badly impact upon the organization, it's going to want to have some kind of recourse for what's happened. So what's within the art of the possible? Well, I put up on this slide what we have seen even some of the major providers agree to, however reluctantly. I would add that it tends to be the case that they'll only move to these types of provisions if you've got a reasonable amount of leverage in the negotiations, and leverage will ordinarily come about as a product of one of either two things. One will be if it's a competitive procurement process in the first place, so you've got three hyperscalers bidding against each other, for example, or in scenarios where there is a much more significant deal value on the table. And by significant, we often see hyperscale deals in the multiple hundreds of millions, and in some cases even north of $1 billion, depending on the size of the customer organization. And if you have those types of deals, then yes, you will get the hyperscalers to the table and to discuss at least provisions, but probably still seeing less flexibility than you would have done with a more traditional technology service provider. But obviously you'll see on the slide when these are circulated around at least some ideas here, therefore, as to what you might look to achieve. One other thing I will leave you with in the interest of time is to think very hard when you're contracting with these cloud service providers about the issues associated with conflicts of laws. The most pressing of these relates to data and where it is processed, because as many of you will know, we are unfortunately entering an era of global protectionism, and one of the facets of that is a more localized approach to processing of data. And there are grounds for saying that if you are engaging with a truly global hyperscaler, you're doing so in the teeth of applicable data protection legislation rather than being sweetly in accordance with it. As if you look, for example, at GDPR, GDPR says that you should not really be utilizing any service provider who would be able to make a disclosure of personal data without an order from an EU court or regulatory body. But the US Cloud Act, by contrast, which applies to US domiciled entities, which obviously then includes a lot of the hyperscalers, does have the ability to mandate a disclosure by them of data that they have possession of, which would therefore include that of their customer entities, regardless of where that data is processed. So you have a clear conflict then between the US legislation and the GDPR. Now, the only way you can square that realistically is by making sure that any data that you entrust to one of these cloud service providers is encrypted in such a way that the cloud provider themselves has no means of accessing it, even if they were required to provide access by one of the US regulators. But that's obviously something that needs to be very carefully solutioned in the way that you set things up. So very quick whistle-stop tour between some of the key facets. I would say that the negotiation landscape with hyperscalers is developing very rapidly, not least as the likes of DLA Piper and other law firms become involved in the process, and therefore, like elephants, we never forget. So when something has been negotiated in one deal, we do tend to remember that that then is added to the art of the possible. But say it is a fast-moving area of negotiations, and I'm sure there's a lot more development to come. But in the interest of time, I'll stop there, and perhaps any other points that arise to people as a result of that, we can pick up in the panel discussion.
Wow, Kit, that was brilliant. You've taken us on a really fast, rapid ride, but loads and loads of content there and loads of questions coming from that. But yes, let's move on to those in the panel. But thank you so much. Right, over to our very last speaker. So Andrew Rayner, who is the CTO for a new organisation called the Intelligent Automation Collective, is going to be talking us through a new way to, I believe, simplify the way that enterprise buyers can contract across the automation landscape. So, Andrew, you'll do a much better job of introducing exactly what the IAC does. So, can't see you though, Andrew. Where are you? Can see your slides. Oh, there you are. Yeah,
I've just shared my slide. Can you see me okay?
Yeah, brilliant. Thank you, Andrew. Over to you.
Perfect. Thank you for the introduction, Kerry, and pleasure to be here today. I'm just going to put this into presentation mode. I know we've had a few challenges, so I just want to make sure, can everyone see the big presentation, not the not just the
Yes.
sharing screen? Yeah, is
Yeah,
that
we
okay?
got you.
Perfect.
Brilliant, thanks.
Brilliant. So yeah, thank you. The IAC then, really, we formed this around July last year, and really it came out of a engagement that we had with a large bank in the UK who were coming to us saying there's a lot of vendors out there, a lot of platform providers who are trying to be, I would say, a jack of all trades, but not really a master of any. But also as a large bank, we have huge challenges trying to procure new technology. So we want to use best in class, but actually it's a pain for us to do that. You know, they take 6 to 12 months for us to procure new technology. So are there any other options out there on the market? And the IAC really exists to deliver that profoundly intelligent automation through the creation of an end-to-end architecture of best-in-class technologies. So really we're there to try and accelerate the adoption of intelligent automation, not just tools like RPA, which have been commonly used across the globe, reduce the cost as well, and also simplify that, that selection and buying process. So the problem statement, just to dive into the problem statement a little bit more, organizations really have two options today when it comes to buying intelligent automation. Like I say, they can go to a platform provider or they can go out and procure them themselves. And you know, clients don't really want to just keep adding more and more software vendors because it takes a long time to research. You know, they're reliant upon Gartner, Everest reports to, you know, look at the tables, the quadrants that are coming out. There's also a risk of failure with these vendors, you know, if they don't integrate properly with their existing technical landscape, the ability to deliver, maybe even some of the kind of the legal terms that I know some of the fellow panelists have just been talking about. Maybe there's some challenges around that. At the same time, talking about the large bank, clients do want access to best in breed technology. They want to work with organizations who have a strong product roadmap. You know, they're not going to be left with a large amount of technical debt. The also issue is that if you're buying multiple products from different companies, software vendors traditionally don't play very nicely together. They do perceive each other as competition, and that can leave, you know, a very frustrated client when trying to manage things like interoperability, integration, and also that relationship between those different product vendors. It's also interesting when we're bringing together a collection of product companies who want to work together. From a consulting point of view, you know, it's best for the organization because they get those people at the table to think about solutions, not just trying to sell licenses. So having a collection of product vendors who are part of a collective who want to come and want to do what's best for the customer, they want to solution problems that the customer has rather than just trying to sell more. Working together as well to invest time in IP creation, actually building strong integrations between these products and not relying upon service providers or customers to go and build those integrations themselves. So what is the IAC? And this is probably quite a complex slide. And for those of you maybe more technical on the call, there'll be obviously we'll provide these slides and you can read through it in a bit more detail. But what are the different areas of an IAC architecture or an intelligent automation platform? And I say the first area is a lot of people might have heard of process mining or task mining, which is the ability to extract data from back-end systems, be that ERP systems, CRM systems, looking at transaction IDs, looking at what variation is there, how many transactions are there, how long is it taking for that transaction to move from one stage to the next. So what are the opportunities in there for automation, change and improvement? Whereas task mining is looking more at actually what are people doing on their computers. So recording clicks, steps, time it takes for them to go, I don't know, in a spreadsheet, they're entering data in a spreadsheet, how long is that taken, going into email, maybe going into Facebook on their lunch break. So we can capture anonymously or by user the data that's been the actions that have been performed inside that organization. Productivity mining, I would say, is a combination of both, and the vendor that we have here offering that is KYP.ai, whereas productivity mining allows us to look across teams and look at an accumulation of activity to see where there are inefficiencies within the work that's being done within those teams, but also where there's a high level of variation that could really result in that could be have a huge benefit from standardization. Then we talk about service delivery channels. So how does data get into an organization today? So that could be unstructured data like free text, emails, documents to some extent. It could also be structured data, for example, APIs, forms. But what a lot of organizations are doing today is they're using chat. So they're looking at employee and customer self-service capabilities as a way of improving customer experience and reducing cost of human contact when working with organizations. Now, in my experience, chatbots can be really frustrating. I don't know about you, but when I use a chatbot on a website, I'm just trying to be as dumb as possible so I can get through and speak to someone, because I feel like there's a very basic decision tree in there. But actually, if we mix chat with decision intelligence or intelligent dialogue, we can use AI and machine learning and also extraction of key data from systems to formulate a better response, to have a better conversation, a more contextual based conversation. We then need to structure some of that data that we get. So there's the tools like AntWorks today, where we have IDP, which is the ability to extract documents data from documents, from unstructured documents, like, for example, different variations of invoices, medical reports, the ability to classify as well, so understanding what are the different types of documents, and then sentiment analysis if we're dealing with maybe complaints. All of the work, once it's structured, needs to be orchestrated. So organizations today are using the likes of Salesforce Cloud, ServiceNow, Appian. So there needs to be a level of orchestration in there so that we can get visibility of the end-to-end process and all the steps that are done in that process, be that a human's doing it or actually a digital workers doing that, an RPA robot or an iPaaS system. So the idea behind the IA Collective is to say, this is a blueprint. This is what we believe are all of the areas inside an intelligent automation platform, giving you all the capabilities to be able to go and automate a lot of processes that you may not have looked at today. For example, a lot of processes that are being automated are structured, rules-based, but actually having a big toolkit available to you enables you to go after some of those other things. Now, really, I guess the value proposition, and especially if we come to talk about contracting, which I know is the is of course the backbone of this panel that we have. I think one of the biggest values is the single contract. So and also the type of pricing. So if you look at those vendors that were on the previous slide.
834571.
Sorry, sorry, Claria. So if you look at some of the vendors on there today, and the different vendors out there in the market, there are lots of different pricing models. For example, IDP vendors normally charge by per document or per page. So there will be a charge to say you can buy a bundle of 100,000 pages, and then after you've used that bundle, you then pay so much per page. Some vendors out there charge, especially the cloud vendors that we have, or the other SaaS-based vendors, are charging per seat. So for example, in workflow systems, especially cloud-based workflow systems, that'll be done per user. For example, RPA vendors out there today are charging just annual licenses per license. And also what a lot of the managed service providers are trying to do is to come up with a consumption licensing model. So the idea is that you have this flexible workforce that you can spawn up on demand, and you just use what you're consuming, so per hour, per minute, per second. So one of the benefits that, and one of the things that we're trying to do differently here in the IAC is to say you can contract with all of those 7 vendors through a single contract that will allow you, a bit like a Tesla, you buy a Tesla with loads of features and you can turn those features on and off. So having that single contract to allow you to procure all of those vendors at the same time, but just pay and use for the ones that are relevant based upon the use cases that you're trying to automate. Also, with that single contract, having a services play there around being able to provide support, so first line support for each of those vendors. So again, another challenge that customers have today is that they have to go and triage the issue themselves and then work out which vendor it is they need to contract. That can be quite time consuming. You also need to stand up a team to be able to do that and make sure that team are well trained. So again, having that single contract, having that relationship and that resale agreement with the other vendors means that we can also provide a level of services and SLA around that. The outcome-based pricing, so pricing not in all of those different scenarios I just mentioned, but actually pricing based upon outcomes. One of my fellow panelists was mentioning about making sure that we do pricing based upon FTE or based upon benefits. So, can we build a pricing structure that says, actually, if you're getting 100,000 or £1 million worth of benefits out of this automation, is there a percentage that can be agreed in terms of chargeback for the solution itself, rather than having the complexity of managing multiple different licensing structures? And then finally, as I mentioned, the flexibility around your needs, the Tesla model. So being able to pick and choose which technologies are required and for what use cases, but then not going, okay, well, we've chosen one of those products and now, oh no, we've come up with a use case that means we need to use IDP from AntWorks as an example. So now we've got to go through a separate procurement process to do that. Actually, we can do it all at the same time, and you can just switch features on and off. So I'm going to pause there anyway. I wanted to be quite sharp and quick with this, but of course, if there's any questions, please put it on the chat. If you want to find out more about the IA Collective and the vendors that are part of this collective, then there's a website there. And also, if you have any questions after the call, you can email us at info@iacollective.com. So back over to you. Thank you.
Okay, thanks very much, Andrew. That is great. Yes, please do start putting any questions you've got into the chat. I will absolutely be coming on to all of them. And if we could ask Charles to rejoin the panel as well, if you're still with us, Charles, that would be great.
I am still here. Hello.
Hello, great stuff. Thank you. Right. Okay, so I'm not going to run this panel as a round robin, so I'm going to ask a question, and if you want to take that question, please physically put your hand in the air. If you've got questions and you want to get involved from the participants, then put your digital hands in the air. That would be absolutely great. And if nobody offers to answer it, then I will absolutely pick on you, as you know. So be prepared. Right, I'm going to start off with the way that I think Praveen started the whole thing off, and that is really looking at how do you get balance in your contracts when you don't actually know what you're really contracting for. So we're seeing a big move towards an agile sourcing approach as well. So that's lots and lots of conversation going through. Instead of doing a traditional RFP and marking that RFP, it's a much more consultative approach. So how do you come to a balanced contract view when things are ever changing? Thank you, Kit.
Okay, I'll offer a start of a 10 in relation to that, because agile approach is obviously the darling of the commercial and technical folks and the absolute nightmare of the lawyer. In the sense that the lawyers, we love certainty, and agile, as you've rightly said, Kerry, doesn't. That certainty does not go hand in glove with an agile approach. I think that the biggest mistake that you can make is to try to retrofit a waterfall methodology based contract structure into an agile way of working. I think that's just a recipe for disaster. I think what you need to do is embrace the fact that there is uncertainty and change and iteration, and that's obviously one of the strengths of the processes, and look instead to see if you can adjust the commercial arrangements in a way to incentivize the right kind of behaviors. So what I mean by that is that the worst case is a supplier might say, this is brilliant working agile because it's a T&M model with very little deliverable responsibility, and I can just keep on accepting new requirements from users without ever asking whether it's really in line with a project vision at all, because everything I do, I'm just going to be paid more for. So that's the kind of worst case scenario for the customer. But if you were to model the commercials to say, look, we have at least a target price and an idea of at least a minimum kernel of what's to be delivered. So if we run beyond that target price or target time frame, whatever it may be, then yes, you will still be paid, but you will be paid less. So that the supplier starts to have some skin in the game and starts to have a incentive to try to run things as efficiently and leanly as possible, and to push back on nice to have functionality rather than must haves. Now you start to have a more of an alignment of interests. Or if you were to put an element of the charges at risk to a particular outcome or a particular time frame, again, you start to move back towards alignment of commercial interests, because then that's the thing that would really make the thing more likely to succeed.
And do you get much pushback on that? And then I'll invite you in, Charles.
It depends. Obviously, it depends upon the extent to which you reduce charges or the amount that you want to place at risk. But the more savvy and more commercially minded suppliers, I think, get with the program on that. And they realize that there is a valid concern from customers that pricing does not go out of control, because unfortunately we have seen agile projects where customer went into it thinking, right, we will get somewhere with this, and that before they know where they are, they're 5 or 6 months beyond the point where they thought the project would be completed, and they're already double the budget.
Yeah, cool. Yeah, Charles, please.
Yeah, look, I mean, everything Kit said there, I completely agree with. I think the point on agile processes almost being the bane of a commercial lawyer's life might be accurate. And one of the things that we've done sort of at the outset of projects is rather than to look to define service descriptions and the sort of things that you may have had for more easily defined services, is to look at user stories and outcomes in that way. So you've got an idea of where you want to get to, and it might be relatively high level, but at least to have something where you can say, look, this is the sort of thing that we want what we're buying to look like at the end. But and we don't necessarily know the process or how we're going to get there, but we've got an aim. And at least to have something down on paper in your contract, then at least it points the parties to what you're trying to achieve, and you've got buy-in from that regard.
Yeah, so does it mean that you as lawyers are involved in the life cycle of these arrangements so much more now than you used to be, because there's going to be constant movement and constant requirement to relook at contractual aspects?
Well, not if the agile process is working properly, then no, it shouldn't require lawyers, because that should be done at the project level. And in fact, that's always been one of the perceived benefits of agile, which it enables change to be dealt with operationally rather than requiring lawyers to come back and assist with the drafting of change control notes. But lawyers get involved, unfortunately, when things go wrong. So if you do have something which is set up which doesn't incentivize the parties in the right way, then yeah, you're likely to see the lawyers come back involved, but unfortunately not in the most constructive of ways.
And are we seeing much of that, or on the whole, are we getting it right?
It's difficult to say. I think agile, is very successful as an internal methodology, because if you're doing it as an in-house project, then your commercial interests are aligned from day one. Where it's used externally, I'm sure there are lots of good examples where it's all gone swimmingly, but unfortunately, if you look at some of the cases that have been reported in the press, then unfortunately agile tends to raise its head as an example of why things went wrong. So one of the more recent cases that was in the press was IBM and Soteria. It's probably one of the biggest technology failures in recent times that's got into the public domain. And if you get into the case description there, lo and behold, a failure of the parties to work properly on an agile basis was one of the early causes of delay and problems.
Okay, Praveen, from an advisory perspective, have you seen agile working to great effect?
So yes and no. So agile as a term, we are using it for iterative sourcing. What we are seeing is it typically starts off with a pilot and goes into a kind of a conventional sourcing, but the boundary is not very rigid. So at some point you have started with a pilot and you do a smaller scale sourcing and implementation. And then as you proceed, you get to know new things. You have a significant change in the scope because you've got to know new things that need to be done. And with that new scope, you do another round of sourcing. And of course, every time we do this, we end up circling this with legal, because that's something that like just from a risk perspective, we have to do it. So yeah, I understand where Kit is coming from. It's quite taxing for the procurement leaders, the legal, because you have to do it in an iterative way, but still have to undergo this process of internal compliance every time. But we've seen this happen. It's happening. For example, in a chemical plant, we're doing this automation, and they're like 20 packing, 20 odd, maybe 22 packing chutes, and we do the automation on one of them. We set up. We procured the IoT tags, got it set up in one of the chutes, and use the data to arrive at what next for the rest of them. And then once the data came in, there was so much of change in the both from a executive leadership's priorities standpoint, as well as what the data returned. There was so much of change that we ended up doing another round of sourcing. So when I say agile in that deck, it's basically the iterative sourcing which builds itself, keeps growing, and at the end of the day, it might end up becoming a conventional sourcing at the end.
Okay, thank you. So Andrew, I'm really keen to understand how you actually look after the contract when you're potentially engaging 7 different organizations with potentially no really clear end goal, because again, for you, it must be massively iterative.
Yeah, it is. And actually, there was something I was going to mention on the last point. And I mean, for me, waterfall and agile, very much familiar from a development point of view, but from a contracting point of view, quite an interesting term actually, and very, very interested to hear that vendors are looking to go down that route. I mean, my previous role, I used to run professional services for UiPath, and of course we were trying to sell services along with the products all the time. And what worked quite well for us, and I don't know whether you would class this as agile, was like a service credits model. So what happened at that point was when you bought the software, you would also buy a package of service credits, which could be consumed over a period of time, be that 1, 2, or 3 years. And then we had like work packages based upon the customer's journey. So if they were brand new to automation, we would say, actually, here are some of the packages and prices that you would consume as part of those service credits. You also had the ability to buy more credits or get back. I think the challenge was always in the grey area, was always if they didn't use all those service credits, is it a use or lose them, or do they get them returned? And I think getting them returned is challenging from a finance point of view, because you're not recognizing that revenue, and there's a lot of issues around revenue recognition there as well. So I kind of wanted to add that point to the previous and see whether the panelists have thought that would be more of an agile approach, or whether that's just traditional but done in a different sense.
Right, that one looks like one for you, Charles or Kit, to answer. So what are you doing around service credits at the moment?
So by service credits, I think we're talking there effectively about sort of banked hours, Andrew. So you've got a period of, you've got a set amount of time that you purchase up front that you can then go and use. I think that's slightly different to the way we as lawyers sometimes use service credits as a sort of as a slap on the wrists for failure to deliver. Yeah. So yeah, it is a model we've seen, and it's certainly one. I suppose it lends itself to agile in the fact that you've got you've got an amount that you can consume over a period of time, whilst also having a pricing methodology that works for a supplier, where they've got a guarantee of the amount of money that they're going to receive from the deal itself. So it can be beneficial to both parties. You can draft into that contract what you want, I suppose, in terms of how you deal with hours that are unused at the end of a process. But you're right, suppliers are very resistant to refunds in those scenarios. I mean, it's usually a use it or lose it scenario. But I think from my experience, it tends to be the case that most customers think they're going to overuse and they're going to be buying more. So a lot more of the negotiation we've had on those contracts is around you know, what's the pricing in the future for the procurement of more hours and more time. But yeah, I think that's a sensible approach, and it's certainly one that can help clients that are not used to buying that sort of technology.
Well, the only thing I would add in terms of service credits is that, as Charles says, very often it's seen as being a slap on the wrist for less than anticipated service delivery, if I could put it that way. I think a lot of suppliers on the hand are concerned that if the customer really isn't suffering as a result of this, it's just a way for the customer to get a discount on its pricing, which is not very conducive to the right kind of behaviours. In a lot of deals that we see, or at least some of the heat of that discussion can be taken out by saying that if service credits do arise, at least a proportion of it doesn't just disappear altogether, but instead is put into some kind of innovation fund, so that it's still available for the customer to utilize, but is done by way of the supplier providing services in kind rather than actually having to give any kind of rebate against its monthly charges. So that also addresses the issue that quite often one of the problems with incentivization and innovation is it's a good idea in principle, but the customer just hasn't got the ready budget to do it. So if you've got that kind of ring-fenced amount of money being set aside for it, then that can help to address that as well. Just killing two birds with one stone.
So Praveen, you put your hand up.
Yeah, so I wanted to add on to the service credit. So we started with the two versions of service credits. Actually, what we were discussing about was service credits as in the prepaid coins, so as to say, which you use to procure cloud and cloud services or any services in an agile model. That was the service credits I think Andrew was talking about. And Kit also mentioned about the service credits which we use to basically provide incentive to the supplier to perform beyond expectations. And we also use the service credits as a disincentive for, or rather, as a penalty for breaching the SLA. So service credits get credited from suppliers to us as the SLAs are breached, right? So I'll not go into that one. I think that's part of conventional sourcing, and we are doing it in agile sourcing as well. But the thing that Andrew mentioned about service credits as a payment route, right? As a prepaid payment route. So we are seeing both these modes. A service credits, which is like a prepaid payment route. These will be in the form of, for example, AWS credits. You can purchase services over AWS over on that. Those are one sets. The other one has a postpaid connotation, which is what I was talking about when I said consumption-based pricing and rate card-based pricing. We are not talking rate cards of individuals. We're talking rate cards for consumptions. If we are consuming 10,000 sensors, for example, what should be the rates? If you are consuming 50,000, what should be the rates? So things like that. So yeah, they're both these models are in place, the prepaid or the consumption-based postpaid. In either case, our recommendation always is that we do not commit a lot upfront. In the prepaid mode, we do not buy service credits in bulk so much that we are not able to consume in the year. In postpaid, of course, we don't commit to too large a minimum order quantity. Right, there will be a minimum order quantity you would be buying in bulk of maybe 1,000, 5,000. So yeah, that's what I wanted to talk about.
Thank you. Right, so one of the other points came up was do not contract for longer than 3 years without a very clear exit. Well, obviously at the GSA we say do not contract without a very clear exit, full stop. But I'd be interested to actually understand what the tenure and terms of contracts that you're negotiating at the moment are, and whether we've seen a dramatic change in the length of contracts. So Kit, over to you.
Well, if we focus for a moment upon the hyperscale contracts, or cloud service provisions as a whole, the immediate response a lot of the cloud providers will say is, yeah, but our contracts allow you to terminate for convenience anyway, so you're all fine. That's not a requirement. It's much more flexible. It's turn off, turn on rather. And if you looked at their basic provisions, that would be the case. But for any sizable deal, you'll find that there is usually an addendum, which is some kind of pricing commitment. So if you want to have the benefit of the kind of deep discounts that you can obtain from the hyperscalers. That will only come about if you have made minimum revenue commitments, which you then can't get out of by terminating for convenience, or at least not without paying somewhat prohibitive payments. So you need to look beyond what's available in the basic documentation and look at the commercial reality in terms of the way that these deals are structured. So if I look at the deals and deal lengths to get the kind of discounts that the clients want to have, remarkably, the deal lengths end up being very similar to what they kind of outsourcing arrangements, so typically between 3 to 5 years. And the part of the reason for that is because aside from the cost of the services themselves and the discounts that you try to get, you've also got to factor in the cost of running the procurement exercise in the first place, doing the migration and transition exercise, and not wanting to do that too frequently. So obviously it will vary depending upon the size of the deal and the nature of the services, but if it's a larger scale deal, 3 to 5, I would say, would still be what we would most readily see.
Okay, and again, it's a sort of percentage. How often are the enterprise buyers going and negotiating directly themselves with the hyperscalers, and how often are they going down the sort of like managed service sort of route? What are you seeing there?
We do, as Praveen was saying, we do see providers going through the marketplaces of the providers, but they tend to be in relation to the smaller value add type applications. So for anything really substantial, so any kind of business critical app, for example, which might be hosted upon one of the platforms, they tend still to negotiate that direct.
Okay. Thank you. Charles, yes, you put your hand up.
I was just going to add just quickly to the point Kit was making, which was maybe on the sort of the lower level of the deal value, but still, I think, still relevant for procurement of new technology. Customers or clients recently who have been purchasing services, looking to restructure their deals down from 7 and 5 year terms to shorter, more flexible periods, seeing a knock-on effect in terms of price going up between 5 and 15%. Being offered by suppliers on that basis, because they're not being able to generate the revenue that they're expecting from those contracts. That's been on the sort of renegotiation side of things that we've seen recently. So yes, I mean, building yourself in more flexibility and the ability to move away can be helpful, but it does have a knock-on the bottom line.
Yeah, so that actually leads quite nicely into my next question, which is really looking at the retail price index and all the inflation that we've been experiencing. So we've been talking in the past mainly about FTE related models and how a lot of the service providers have been going to their clients and renegotiating those deals, predominantly so that they can actually increase the salaries of the people working on their sourcing arrangements. What are you guys advising on and seeing on, the whole inflationary pressure issue that we're experiencing? And any one of you can take this, although I imagine it's going to go back to Kit and Charles in the first instance, and I'll find a different question for you, Andrew.
All right, well, let me give it a start of a 10. So I think, as my fellow panelists have alluded to, the indexation provisions are certainly under far more scrutiny than they ever used to be, a bit like the force majeure provisions. Nobody ever used to pay any attention to them until COVID came along, and then suddenly everybody dusted down their contracts and tried to work out what the implication of those ones are as well. There are a number of negotiations going on. So I've got one of the members, which is actually a BPO deal, but the supplier has come back and said, look, I know we signed a contract which did not provide for indexation, but we're bleeding. We never thought we'd be incurring these costs, and we are, and can you help us? At least they had the good grace to couch it in those terms. And it then puts the customer in a difficult position. On one hand, they've got the budget, and they've probably got the contractual ability to insist upon the pricing remaining as it is, but nobody wants a supplier who is bleeding, because at the end of the day, they're all human. There's probably an individual there who is tasked with ensuring that the contract delivers an acceptable margin, and he or she will therefore be constrained to find ways in which they can try to economize, try and cut corners, start to be a little bit more pedantic when it comes to change of control requests. So if you aren't amenable to having a commercial discussion with your supplier in those circumstances, then yeah, you're probably setting yourself up for a difficult relationship for the remainder of the duration of the contract. What we have seen, however, is customers saying, okay, well, that's a conversation we can have, but let's broaden out then the discussion. So if we're going to do this for you, what can you do for us back? So in one case, for example, there was a case where the supplier in question also had a software arm, and we could say, well, you should extend us some of the benefit of your software, which is just, you know, it costs you nothing other than some foregone license revenue to give us some of that software. But if you want us to help with some of your services commitments, then just give us some software to sweeten the deal.
That's fair enough. We've also seen it where sort of like, you know, big customers, enterprise buyers have turned back and said, if I know that you're going to pass the price increase down to your employees because they're the ones that are feeling the crunch, then I'm actually willing to do it. I don't know whether you've come across any examples like that and know whether that is contractually viable to actually deliver.
It's certainly doable, and I have seen provisions which say that, yeah, we will give you more money, but only to the extent that you warrant that you have increased the salaries of your staff, so that you know that it's going through to them. Yeah, I've seen things like that.
Right, one for you then, Andrew. So alliances, we've seen different types of alliances come and go, and quite often they're fraught with difficulties because obviously you're managing the desires, the cultures, the personalities of lots and lots of different individual brands. How are you sort of ensuring that the IAC can actually deliver to the customers' end requirements? You're on mute.
Yeah, firstly, there are challenges. It's been quite eye-opening actually, trying to bring together all of these product companies to work together. As I mentioned in one of my points in my presentation, you know, they don't normally work very well together, and you know, and I think a lot of product companies, they have their core offering, and then they build additional components because they have to, because, you know, they don't want the customer to go and get something else. So they say, okay, well, I don't know, we do IDP, but actually we've also got some workflow built into there because it's kind of a nice to have requirement that is going to be useful for some of our customers. So when we brought them all into the room at first, one of the challenges was, oh, well, yeah, but we also do that, and we also do that. So it was really defining what is the unique selling point and what is the best in class technology that platform player is bringing together. I think also, if you look at the products that are within the IAC as an example, they're not the big players. You know, they're not the, you know, the Salesforces of the world, the UiPaths of the world, you know, the SAPs of the world. So I think having that more, I guess, startup mentality, and that I guess I'm going to use the word agile again. The ability to do business in an agile way means that actually they are willing to work together and willing to deliver what's best solutions for the customer. I don't know if that will change as they get bigger and as you know, as their revenue lines increase and as they hire more employees. You know, does that relationship kind of become less close? I guess it all depends on what is the benefit that they're getting from the IAC as well. Are they getting leads and opportunities that are coming through? So is it a payback for them in the time and money that they're investing in them? So it's still probably too early to say at the moment. But yeah, there have been some challenges so far, but actually now that we've gone to market with this and we've started to see opportunities come in, actually I think everyone's glad that they invested the time and commitment into doing this.
Cool. So that obviously leads to the question whether Kit, Praveen or Charles have seen more discussions about alliances, whether you've done more contracting across alliances recently or not.
Very much so. I think there's a lot. I think we are in the days of platforms, and if people want to therefore gain access to a broader scope of potential clients, inevitably it will mean you're working with a platform. And look, just take a couple of examples of deals that we've worked on a DLA, which are in the public domain. We had the London Stock Exchange cloud services deal with Microsoft, which was also then tied up with, and we will now work together in order to develop go-to-market strategies associated with market data, etc. And then a deal that I worked on, which was again involving Microsoft, but which was with Amadeus. And yes, there was a big cloud services deal, but it was also then tied up with a deal to do a go-to-market tie-up to look at ways in which cloud service and cloud native applications could be applied for the travel industry. So there's no magic to it. It's not just because there was a cloud deal in the offing anyway. It was because customers could realize that these are massive platforms who have a potentially transformative effect upon how they can access their clients.
Thank you. Right, we're really close to the end of time. So if there are any questions, you've got the best brains in the industry here right now to answer your questions. So please do put something in the chat. But without your questions, I can keep going for quite a long time. I've only got 4 minutes, but I'll keep going. So what are the major trends you are seeing that perhaps we haven't already talked about today? So if anybody's about to engage in a new tech or contract for anything, what advice would you give? What trends are you seeing that we've not discussed?
Well, the one that's overwhelming is generative AI. So the organizations need to have some proper structures in place as to how they're going to use this particular iteration of AI technology. And look, AI has been around for ages, and most of the people on the call, I'm sure, will be very familiar with it. But I think it's fair to say that the publicity storm surrounding ChatGPT transformed the debate on it. Yeah. And we had an absolute firestorm of clients coming to us to say, what should we be doing about this? Should we have a policy on it? What's our risk associated with it? It's not as if these risks didn't exist before. It's just that the people have become a lot more aware of it. I think organizations need to be looking at not just how they are consciously applying AI in terms of their sourcing and solutions, but also how people within their organization may be utilizing it in a more ad hoc fashion without necessarily a degree of management control, and what implications that has for them.
Yeah, Charles, please.
Yeah, I'll just add to Kit's point, which is something that we've been seeing quite a bit of recently in respect of AI is advising clients on their internal compliance and policies in relation to IP created from AI and what the management around that is, and how driving employees to best practice in terms of utilizing AI and ensuring ownership of the stuff that a customer wants to keep ownership of. It's in terms of contracting, that's all part of your sort of contracting process and your agreement with suppliers. But there's also, as I say, the internal policy and compliance points as well that you've got to deal with, which is yeah, as I say, a separate story. Yeah, look, separate from that, I think from my perspective, I deal with a lot of FS institutions and also managed service and other providers that sell into financial services. And obviously, one of the big things that's on our agenda is regulation and importance of looking at resilience of services and things like that. So there's a lot to consider for businesses operating in that space in terms of what you do to ensure that your product offering covers the rules that are in place in the EU and in the UK that are coming and across the world. Yeah, it's certainly causing a lot of time spent at higher level.
And where does the responsibility for the ethical use of AI reside right now? Is that still coming down to the legal teams to ensure that that's been looked after, or is that broadening out into the business?
I mean, look, from my perspective, from what I've seen, it's within internal legal functions or compliance teams within businesses themselves. I don't know if Praveen or Andrew have got a different insight.
Yeah, I would probably agree with you. Yeah, so in organisations that I've worked with, who are utilising AI, machine learning, yes, of course, there's a level of ownership from the business in terms of how the model's trained and the data that they're providing to train these models. But yeah, you're right. In terms of from an ethical point of view, that would probably be more of a legal and compliance matter from what I've seen.
Okay, right. Well, we are at time, so there were no questions. But thank you very much to all the participants for joining us. I hope you found it interesting and helpful. And a huge thank you to our panelists for joining us today. So Thank you, Kit. Thank you, Praveen. Thank you, Andrew. And thank you, Charles. And yes, we've got some key things to pick on up here. And I think obviously the best practice on generative AI is something that perhaps we should be looking at in the immediate term. So thanks for sharing that one, Kit. So thank you all for joining us, and we'll see you again soon. Thank you.